Good morning. Thank you for joining BioStrategy Partners' Practical Knowledge Series, How Can I Protect My Ideas? To share a little about BioStrategy Partners, we are a 501c3 nonprofit consortium of academic medical centers and research institutes committed to the development and transfer of academic research into the marketplace. Our panel today will be discussing the intellectual property, common myths, and best practices. You will hear from Jeff Towns, intellectual property attorney from Cozen O'Connor, Gretchen Tamelis, intellectual property attorney from Duane Morris, and Steve Nappy, the associate vice president from the Office of Technology, Commercialization, and Business Development at Temple University. And I'm Erika Swift, your moderator for today, and I am the associate director of the Center for Medical Innovation at Penn State University College of Medicine. Before we get started, I would like to give a special thank you to our sponsor, MVM Associates, servicing all of your tax credit needs, and also to our host for today here in Philadelphia at University Place Associates. If you want to learn more about BioStrategy Partners, you can also connect with us at LinkedIn at BioStrategy Partners or visit our website at www.biostrategypartners.org. As we get started this afternoon, I would like each of our panelists to give a brief introduction. Jeff, will you kick us off? Let's begin with you.
Sure. Well, thank you for having me here. Thank you, Erika. My name is Jeff Towns. I'm a partner at Cozen O'Connor in our patent department. Cozen is a general practice firm. We have approximately 700 attorneys worldwide in 28 offices, although our headquarters are right here in Philadelphia. I'm on the patent side of intellectual property. I would classify my practice as client counseling, so it really breaks into 4 different departments. One, it would be patent prosecution and preparation. Second would be opinion work, freedom to operate, non-infringement, invalidity. The third part would be transactional, and this deals with a lot of due diligence, joint development agreements, license agreements, and so forth. And the last part of what I do are inter-parties review, and that is a relatively new proceeding where you take an invalidity procedure, sort of a mini litigation, back in the patent office to try to invalidate a patent. My background's in chemistry. Most of my clients are in the chemical and biotech area. We deal with mostly domestic clients, and we have a fairly diverse group of clients. So we work with startups, and we work with universities, as well as Fortune 500 companies and venture capitalists.
Hey, Gretchen, a little bit about you.
Sure. My name is Gretchen Tamelis. I want to thank BSP for inviting me here. It's a great organization. I've been around for a while to support them. I am an IP associate at Duane Morris. My practice is principally, I have a PhD in cell and molecular biology, so my practice is principally patent prosecution, but I do a lot of counseling and due diligence. Before I became a lawyer, I worked at a startup company as a scientist for 7 years, so I've been on the other side of the IP fence, so I've seen it from both directions. The other thing I do, like Jeff, is I do quite a bit of due diligence for licensees or larger companies looking to acquire smaller companies. And so that kind of helps you when you're counseling someone at the very beginning and saying, what do the big companies look for here? So anyway, enough here. Steve.
Thank you. Steve Nappy, Associate Vice President for Technology, Commercialization, and Business Development at Temple University. And Temple conducts about $270 million worth of research on an annual basis, and our office specifically helps with the identification, protection, and commercialization of innovations that come from the research. And in addition, we fold into that a contractual interface with companies that do want to do business with the university. And we have 2 partner funds at the early stage and early venture rounds to help the startup process move further along as well. So we've also been part of the BioSP family and proud to be here.
And for the audience, I'm Erika Swift. I'm the Associate Director of the Center for Medical Innovation at Penn State College of Medicine, where we support both Penn State Health and the health system and our college. Okay, so as we get started and thinking about this topic today, I'm sure, Steve, you've experienced a lot of this. I mean, we get all types of researchers that come to our office looking for support. Everything from junior faculty or even maybe a more seasoned researcher that has that first form of innovation that they've discovered, all the way through those researchers that are very familiar with innovation and they might have multiple patent applications or maybe some issued patents, to more of those entrepreneurial type researchers that are really looking to translate and commercialize their intellectual property. So I thought today would be really great if we would just kind of travel through that journey, starting off with like when we have that new researcher that we've never met before come to our door and just really having to explain intellectual property. So why don't we start there? What is intellectual property? Jeff, Jim, I'll take it to you first since you're the attorneys.
Sure, intellectual property is just ideas you own, just like real property. That's what they think of it that way. For most university professors, there's a lot of different kinds of IP. There's patents, there's copyrights, there's trademarks, there's trade secrets. The one that matters the most for most universities, far and away, is patents. And a patent, it's a business tool. Okay, it is a legal document. It may look like a scientific paper, but it is a legal document. And it describes the boundaries of what you own. Anyone thinking about patenting any of your ideas, go on the Patent Office website. You can take a look at granted patents and look at the claims at the end. What those are, they're like a deed to your property. Okay, it says it ends at that river, at that tree, at that. And so what is useful about it is it allows the patent holder to keep others out. I will stop here. There are things you can license. Jeff, I'll let Jeff.
Well, I'll jump in too. So when we get the ideas, if we get them, even if they're idea or invention disclosure, which is basically the inventors writing down their idea in as much detail as we can get it from. But a lot of times it's really, as Gretchen was saying, it's more on this patent trademark or trade secret side. So you will take a look at this and say, okay, is this something we think we can patent, or maybe this is something we're gonna hold back as a trade secret. Both can be valuable, but in different ways as well.
Thank you. And I'll kick something to you, Steve. So why does the university even care about intellectual property? Why do they get involved?
So universities have really a great ability to generate new ideas that can have an impact on patients, on people in general. And there needs to be a mechanism to enable that innovation to move forward. Patents, as mentioned, are an important tool to make sure that there's an attraction for businesses, investors to invest alongside the patent application that protects the idea itself. But the university really, as part of its mission, wants to see the research that it's conducting go out for the public benefit. And the reason we're in the commercialization office and do what we do is to enable that to happen. And I think universities have advanced their process significantly since the founding of the commercialization process within the institutions, primarily driven by federal regulation by DOLE. And now we're looking at institutions layering onto the process with resources that can help ideas advance, de-risk, and startup companies get through it.
Just add on briefly to what Steve was saying. You looked at the landscape maybe 20 years ago or so, and you only had a few universities that were involved, maybe Caltech, MIT, or a few others. And they were making money, so I think it was twofold. One, the universities recognized, hey, there's an ability to make some money off this. And then two, we looked at all these brilliant people that you have at these universities, and there's this idea, as Steve was saying, is, well, how do we harness this intellect? How can we make this more productive? How can we take this and commercialize this and bring it to the outside world? So you've really seen in the last 20 years, I've seen the tech transfer offices, almost every university really step up to this.
So I'm going to play devil's advocate to that. So why can't I accomplish that with just a publication? Like, why do I need to go to the patenting route?
Because unless you have an invention that you can commercialize in your garage with no help, you are going to need some investment. And no investors, their goal is to make money for their investors. They have noble aims behind it, but their goal is still financial. And the only way they can make money is to know that that investment is protected. Okay. A patent allows them, having a patent or a patent application, they can go out and try and commercialize it without worrying that a competitor is going to come and do the same thing. So the concept of just publishing sounds wonderful, but practically speaking, it's not likely to work in the current system.
And the beauty is you can do both. And there's a sequence to it, and I think we'll probably get into that a little bit later. So you can both publish and patent and enable both pathways to disseminate your idea.
I think let's keep running with this because that was some of my next questions. Is if I'm a researcher and I do submit, a new invention disclosure to start, potentially a patent application, does that prevent me from publishing? Does it prevent me from even submitting for new grants, new federal grants to continue my research? I mean, is there any restrictions placed upon me if I file for a patent application?
So there are some misunderstandings that sometimes do happen, that it is an either-or scenario when it comes to patent publication. And the answer is you can do all of the above. And with a grant application, you can certainly submit your grant applications, track funding for your research, but there are elements of that you need to be aware of. Like, for example, when your grant is awarded, it will be published. There will be an abstract published. That could be something to consider in terms of the patent process to make sure it's not used against your ability to file a patent on that work. So the best practice is if you think there's intellectual property baked into your grant proposal that the tech transfer office can look at, submit it early. It's never too early for the tech transfer office to really take a look at an idea, and the tech transfer office will know to get ahead of those deadlines in terms of a grant award that may jeopardize the university's ability to get IP protection. In terms of other types of funding, industry funding also doesn't typically block publication. There are sometimes delays in publication, say a 30 or 60-day delay, but with the intent of protecting the intellectual property and then enabling publication. And other than that, it's really, I can't think of any other reason why. Oh, there's Freedom of Information Act requests that we're seeing more recently. So again, keeping in mind what could potentially impact your ability to protect your idea in the patent world, once your grant application is out there, you have funding, just be aware that the public can request access to that grant application through something called the Freedom of Information Act, and we would want to make sure that we have adequate protection in place for that grant application is published, or we can request, for example, redaction of certain proprietary information in that process. So you can pursue all of the above. There are some conditions, of course.
Yeah, what we typically, what I see, and Gretchen maybe sees that as well, Steve, is that the patent attorneys are not going to stop you from publication. We're just going to make it a timeline and make sure a couple of things happen. One is to make sure that what we ideally like to do is file the application first, and if there's a publication, then the publication sort of is within the same four corners of the patent application. We don't want it to be where I think it's sometimes you get this with university professors and even others, where they will have the idea that publication is so important that they just immediately want to send it out to send it out to a publication. Sometimes when they do that, they're waiting for that peer review, they're waiting for that, and then next thing you know, it's published, and that can really affect the patent rights. Not necessarily in the U.S., because the U.S. has a beneficial grace period, but certainly in Europe, I've seen that happen a few times. All of a sudden, you get a note like, "Hey, congratulations! We just accepted it and published your article yesterday." And you're like, "Oh crap!" Because for Europe and others, it's a hard bar. Yeah.
Yeah, and the other thing, just picking up on the point Jeff made, which I thought was really good, I like your concept of what it changes is really the timeline. Our job is not to rain on your parade. It really isn't, even though sometimes it seems like we are doing that. But it's important for inventors to just be aware of the timeline with publications. The other thing that it changes a bit, the currency of academia is publishing, talking, and conferences and everything. I mean, that's where ideas get exchanged. It's wonderful. It's where ideas are born. In their most cynical perspective, patent attorneys would probably like close the door on all of that, because sometimes people say things that, so if you've filed a patent application, for example, you can talk about what's in there. But where it gets tricky is go to a conference and you talk about your next experiments that are not in there. So I think a lot of it is just becoming educated, becoming aware, listening to Steve and you.
And sometimes what you see, I know this is a little bit different than the question you asked, but if you have a provisional application, that's also a misnomer for a lot of folks, especially if it's really scant, not a whole lot of information in that provisional application. They'll have that filing, then they'll think, oh, I'm protected now, I can talk about this. But really all the data comes in later, all the really juicy stuff comes in. Well, if that wasn't in the patent application, you really can't talk about that and you can't publish that.
So that is a great point. So kind of just to recap what Walt just said here. So when a researcher has something that's new and novel, before they disclose it, before they talk about it in a presentation, before they talk about it at a conference, before they submit an application, they really should engage the tech transfer office to talk to them and make sure that they're getting that timing correct. And it could be a very, very early staged idea. It may just be an idea, like you were saying, which we could start getting the foundation of protection. But as that researcher continues to work through their research and gets more and more data, how should they be engaging with you to make sure that that's translating into the patent that they are protected?
Well, an open dialogue is key with this, because you want to. There is, sometimes we will get this where you will get the data back and it's not quite enough for what you need to file an application, or you look at this and say, okay, I can file this, but I really need some subsequent stuff to really prove it. So that's the type of thing where sometimes you have to file it, but you still want to wait a little bit till you get that next set of data where you have a little bit more, a stronger development of the idea. So I think, to answer your question, though, I think communicating with the tech transfer office is the key aspect on this.
Letting them know that you're going to a conference and you're thinking of talking, it may seem trivial, but they're the ones that are keeping an eye on the bigger picture, and they're there to help you.
And disclose early, disclose often, keep us updated, absolutely. And those conferences, those publications, looking towards commercialization, a lot of times you'll see industry pick up those publications, and that leads to discussion to then enable the next steps in terms of translation of that.
But it can be small. I mean, I've seen abstracts and posters.
Yes.
I mean, it can be the smallest thing that sometimes you don't realize, and you say, well, I just put a small abstract or poster up. Well, I mean, that could do it if you're disclosing some of the key aspects you're trying to patent. That's a publication, or at least a disclosure.
Yeah, and it takes like 10 minutes to submit a 150-word abstract, and you press that send button, and if you had just spent 10 minutes harassing Steve.
Yeah, I think that's a great point, because I think sometimes researchers don't come to us because they think this is a daunting process. So why don't we walk through the process a little bit? Like, if you have a novel idea, I mean, are we now going to trap them for a month in a room, or what is the process?
So for Temple, we have a disclosure process, and we just switched to an online disclosure process. So it's really, we're not asking for a book. A lot of times there's a draft publication or a poster or something that's already under development by the researcher or the research team. So we're asking for that to be disclosed into the institution, so that it gives us an opportunity to assess not only the intellectual property protection strategy and what action the university should take there in collaboration with research, but also what the commercial potential is. We can't file a patent on everything that comes into the office. It is an expensive endeavor for the university, so it comes down to assessing what we can pursue based on what has potential in the marketplace. So I'd say step one is disclose it. Never hesitate to disclose, it's never too early. Step two, we'll take it in and assess the IP commercial potential. If we proceed, work with patent attorneys to go ahead and start the protection process. And from there, really our next goal is to see what we can do to either find a partner or establish our own partnership through a startup company. And that starts to move move the technology down the commercialization process.
Now, does the researcher have to be engaged in that process?
Yes, it's in nearly every case I can think of, you really need that engagement to get as much information at the onset and through the patent prosecution or patent protection process, making sure that we understand what the vision is of that researcher for the idea, and then working backwards to see where they are currently, but what they may develop over the short term to establish a good amount of protection, and have the patent attorneys also understand where the researcher intends to go. So from the protection to the commercialization, it becomes key to translate what's in their knowledge, their head, into an actual commercial product. So that knowledge transfer has to happen with the engagement of the researcher. So we want engagement throughout, but yet they shouldn't feel that it is their burden to know how to navigate the process. That's what we're here for, or their burden to do everything in that process. And that's what we have great patent attorneys to work with as well as other resources.
And just following up on what Steve said, we really welcome engagement by inventors because for those in the audience who haven't seen a patent application before, in particularly biotech, the patent office refers to us as the unpredictable arts, which is kind of insulting, but they do. And they require us to really show how to make and use the invention. So as many examples as we can have of the technology, it makes a stronger application. So sometimes we'll get a disclosure, there'll be examples of review publication, and we can look at it, and invariably we have questions. And the best source of answers to those questions is from the inventor. And I can't tell you how many times I've thought about things in a slightly different way, or thought about how to expand things, or had an inventor say to me, well, I could do it this way, or if I asked them, how did you do it? It's a real iterative process. The best applications are a product of that kind of thing. It's not, like Steve says, it's not necessarily required, but and it's also a fun part of our job. So,
I mean, I second that. It's iterative process, it's an interactive process. So oftentimes we'll have, if the inventors are open to it, we'll have a call even in the beginning. And sometimes you get these, well, I put my invention disclosure down, you've read it, don't you understand it? But having them walk you through what they think their invention is,
Right.
A lot of times it shifts that direction. You pick up on little pieces that maybe they glossed over or you didn't appreciate. There's so many little things that you can pick up through that. And then just to, not only do you have it, oftentimes we'll have it the first call, then typically we'll draft claims. Different patent attorneys do it differently. We'll typically draft claims. We'll have the inventors look at that because claims are a crucial part of the patent application. Then we'll draft the full application. We'll have them look at this. And there's various times throughout it we're getting their feedback, and we really do want to work with the inventors throughout the entire process.
So what does the timing of all this look like? Is it a matter of a week? Is it a year? What is the timing for the patenting process from the time you have that first call to an issued patent? That's that.
Well, depending on how complete the disclosure is, actually drafting and filing the application, we've all done it in 24 hours when someone has had a publication the next day, and but ideally a couple of weeks. But simply getting an application on file, it gets you to the batter's box. Or actually, if you file a provisional, you're not even in the batter's box, you're in the on-deck circle. Because most universities will file what's called a provisional application, and it secures your place for a year. And it's very good for academics and university researchers because it gives you another entire year to develop your ideas. So once we go ahead and file what's called a utility application or a PCT application, it's a year later, so we're already talking about a year. Depending upon the technical area and how you want to file it. It could be several years before your application even gets in front of a patent examiner. So the timeline is not short. There are ways you can accelerate this, and once an examiner sees it, there's a whole iterative process of back and forth that has to happen before you grant it. And I'm sure my colleagues have details, but the thing for university researchers to remember is that most companies or investors looking to license things, they're very sophisticated. They know they're not licensing or granting. They're fine at the early stage aspect of it. So this should not be something that someone should fret over.
And if you're going to put, I typically tell, we have the client, that's the first question, how long does it take to prep the application? The answer is, as Gretchen said, if your client tells you a deadline, then you have to meet it, right? That's just the nature of our business. But all else being equal, there's no hard deadline or something like that. I typically, usually at 4 to 6 weeks, we try to take it from once we get the invention disclosure, assuming we have the examples that you need, assuming you have a good disclosure, until turning it around to something that you can file. And then the timeline, I usually typically, after you file that utility or non-provisional application, if everything's in order and you're in an argument that doesn't have a backlog or anything, 2 to 3 years, if everything's going well, you should see a granted patent in that time. A lot of variables that can happen to push us around, but that's at least some ballpark figures.
Okay, so if we're looking at 2 to 3 years, a researcher can really identify a lot of new information during that time. How does that affect the patent? Or the patent application, I should say.
Well, this is where very productive researchers can also have to be aware of the patent process even after they've filed one application, because the rules in most patent offices in the world is once you have filed that utility or that PCT, you cannot add anything to it. So if your original invention is a method of, treating a disease by eating cherry lollipops, if you discovered that you can treat the same disease using chocolate, forget it if it's not in that application. So you've got to be very aware of your new technology going forward. So even though you've had one interaction with Steve's office, if you come up with some new ideas, you need to get talking to Steve again about how to protect those new ideas, because they may or may not be covered under the first application.
And then you could probably go down a couple routes of either, if you have a bona fide invention here, you can file a new application on this. Sometimes also you'll look at it, and if it's more of a minor tweak, you may want to hold that as a trade secret. And that's oftentimes what we work with clients a lot too. It's referred to as comprehensive IP, where you'll have a baseline patent application. The little steps are held by trade secret, and then when you make a bigger advancement, then maybe you file another patent application.
So if the researcher is identifying all this new information, can they come to your office and kind of get that guidance of what they should do, whether it's a new application or trade secrets? How does that work?
So the engagement with the office in that perspective almost starts with just sending in what you have. If it's a new data that you have that you'd like to share, we'll take it in. We'll then work with patent attorneys to figure out whether or not it is that continuation or new application or a trade secret strategy. From our perspective, we encourage that in any licensing discussions and commercialization outlook really benefits from being able to show that continued innovation, but also that larger portfolio of intellectual property protection that might be valuable to the company that's interested in intellectual property. So highly encouraged, and it starts with sending us what you have. It shouldn't be that much of a lift.
Okay, cool. So I'm going to shift on a little bit of a different topic, talking about inventorship. So many times inside a lab, it's not just one principal investigator, but a lot of times we'll have a team where they'll have a collaborator, they'll have a co-PI, or they'll even have postdocs and grad students that are all working on the same project. Who's part of the intellectual property? Is it just the principal investigator, or how does that work out?
Should we start?
Go ahead.
Because I'm going to point to you in my comments.
Always a touchy issue.
Yeah. So we try not to determine inventorship right at the outset. What we're looking for is who contributed, or who the team believes contributed to the intellectual property or the invention. So on our form, what we're asking for are the contributors to a particular invention, whether it's the faculty member, graduate students, or potentially collaborators at different institutions or other entities. So we'd like to see that picture because inventorship becomes a determination that we would hand over to patent counsel to make. But until we get that picture at the front end in terms of who contributed to the invention, we're not going to make that determination as a university. We're going to rely on good patent advice to patent attorney advice to make that determination.
Yeah, and one thing I'll just pick up on here is, what is inventorship? Well, the U.S. Patent Office takes inventorship very seriously. If you're an inventor, it's determined by the claims. Coming back to what I said at the beginning about the claims, it is a legal determination. It is not authorship. It's very common. You write a nice paper, you give authorship to people you've helped, some people have provided samples, and that's fine. That's the way things are done in academics. That is not how inventorship looks. Inventorship is an analysis claim by claim. Who did this? Who did this? Who did that? So someone who, it's a lot easier to decide who's not an inventor than someone who is. The PI who merely funded the lab, but that person didn't have anything to do with the claims. They're not an inventor. A person who supplied a cDNA library, if that's not part of the claims, they're not an inventor. So it is tricky, it's sensitive, but you have to get it right because it's grounds for invalidating the patent.
Yeah, I'll just second the point. It is a legal determination based on facts that a lot of times only the inventors can give you. So the inventor feedback is very valuable. A lot of times as outside counsel, we will talk to each of the inventors and say, okay, here are the claims, show me what you contributed. And sometimes they'll come back and say, I didn't contribute at all. Sometimes you get different stories. I was just involved in a case literally just a few days ago where one of the inventors left the company, but it was a little bit of a political issue, and the person that was now the lead on the project got promoted to that person's position. And we had two applications related, but they're different separate applications. And the newer person said, no, the guy that left, I don't think he's an inventor on the second CD. And you look at the claims and you go, well, wait a second. He had an inventive contribution to these aspects. These same elements are in this claim on the new one. But you get sometimes these political issues where it needs to be a legal determination. So it can be a complicated issue.
So, and I think that's a great point, because I think that's something that I think you and I deal with quite a bit. Especially if you have a junior faculty member, they want to make sure that the department chair and other people that they're that are mentoring them are on their patent applications. But you were saying that could indeed invalidate that application. Did I hear that correctly? Or just what happens?
Yeah, there's case law. Patents have been invalidated because inventorship has been incorrectly, because people have been dishonest about the U.S. patent system operates under an honor system. We're obligated to disclose.
You can correct it, and a
Yes.
lot of times, if anyone will have an obligation, like for instance, most scientists at a company when they sign their what do you call it? Engagement form. What am I thinking? Employment agreement. Yeah, sorry, I blanked on that. Employment agreement. They'll have that. They'll have an obligation. Same thing with any of the professors. So they have an obligation, and you can correct it later.
Okay.
But it's a pain to do. Sometimes you can't find these people, and it's much better to get the inventorship right.
Wonderful. That's great information. But what if I'm working with my colleague and we're co-inventors? We've had equal contribution. We both have claims to the intellectual property, but my co-inventor decides to move to a new institution. What happens then to that intellectual property? If I'm staying at my institution and they're moving on, who gets to keep it? And especially if they're now also going to make it a little bit more complicated, they're also going to continue in the same field of work at their new institution. What happens then?
Well, if an inventor, if a scientist has if their employment contract obligates them to assign to the university, there's the answer. The university has it.
the university has what makes this complicated is that most times when I've seen this, it's not somebody intentionally taking those ideas. As you said, they're in the field already, so they have all these ideas in their head of how to do something, and sometimes they won't even recognize that, oh my gosh, this is actually the intellectual property of my previous employer, whether it's at the university level or even at with companies. So what I've seen companies do, not only do you want to look to make sure that you don't have third parties taking your IP, but you also want to make sure that your incoming employees are not accidentally taking their previous company's IP. So you have to actually monitor on both ways.
And just to pick on your point that companies too, when new researchers are coming, they don't want to get into trouble either. So they usually try to be very scrupulous about that sort of thing.
Most times it's accidental, I've seen, and most times if you can catch it early and the two entities can talk with each other, they can resolve it pretty quickly, but it's a matter of catching it at an early stage.
I mean, I'm familiar with Penn State's policies around this, but I don't know if you had anything to share regarding Temple's.
So Temple would own the intellectual property that was created at the institution. If the faculty member goes on to another institution and continues to develop develops new intellectual property, for example, that new intellectual property, as long as it's not relying on intellectual property that wasn't disclosed at Temple, would be owned by the new institution. But typically what we do is enter into some sort of an agreement with that new institution, decide as a portfolio or as a package now of intellectual property, maybe co-owned or separately owned but complementary, or they add value to each other. We'll enter into an interinstitutional agreement with that institution that gives one institution the lead on patent and commercialization. So the institutions are pretty well set up to be able to work with each other. The tech transfer offices communicate on a regular basis on whether or not there is that overlap between our institutions. If there is, in terms of co-ownership, we have mechanisms to work with each other that are standard out there. And it's, as long as it's identified, it's easy to work out.
Yeah, and Penn State is very similar, so I think we always try to put researchers' minds at ease if their colleague is leaving, or even if they themselves are leaving. This can still be managed in a very organized fashion. But I really appreciate the points, though. They need to be thinking about that, when they are leaving institutions, if they are, coming to our office to disclose any intellectual property before they leave, and then, and also renew. So they're not causing issues for the new institutions. So that is great information. Okay. So I think we've kind of talked through some of the basics, moved into the myths. We talked about how engagement and communication is so important, but let's move into something maybe a little bit more complicated. So now we have, more seasoned, inventor. They have maybe even a portfolio of inventions, and they have gotten that entrepreneurial bug, and they want to start seeing this translate out. What happens now? I mean, if they're looking to form a startup potentially, or engage industry to take a license to their technologies, I mean, this is a different set of language. So what happens to the intellectual property through these stages?
So for Temple, the mechanisms stay the same. The intellectual property is owned by the institution. The intellectual property is transferred to the company, whether it's a startup or existing, through a license agreement. We have various forms of agreement to move the intellectual property. So that remains the same. What changes is really the pathway to market and the expectations for the faculty member in terms of how they're involved in the startup process. So at the beginning part of a startup discussion, we really do want to understand if we're going to create a company, who's actually going to be running the company. You have researchers that will continue to research and innovate and teach. Who's going to be holding that business flag? Does that person exist, or do we need to fill that gap and identify management for the startup? That ends up being a rather significant go-no-go point in terms of startup or not, because we really do need to have that business lead on the outside to form the company, raise the money, and operate the business alongside the research, development, and innovation that's going to continue to happen for the researchers. So it really starts out as a discussion in terms of what the plans are, what ingredients we have in place already to form a startup. Is the technology appropriate for a startup? versus going to an existing industry partner? Is that a quicker pathway to market that has a higher likelihood of success? And then we open it up to what resources we have that can help that startup along. Will this fit into current funding strategies that the university has in place now? How do we get it to the point where it is a fundable company? But it becomes complicated in terms of the startup. It takes a lot of resources, a lot of effort, and really it can then deploy or sprout various mechanisms in which that startup has to engage back within the institution. So really at the initial part of this, just understanding how to get started, what the faculty role of the company is, and what ingredients need to come into play to get that startup formed. And then we can help navigate the process from there, because it can also change, and it usually does.
Thank you. It's a lot.
It's a lot.
It is. No, all of our researchers that we've worked with over the years to form startups, you get to know each other quite well.
Yes.
But it's an exciting journey, and I've seen some of our researchers the joy of taking their idea to actually see it translate into a commercial product that's now positively impacting patient care. In our case, I mean, it is just it's phenomenal. It's a great journey, a lot of work, but it's a great journey. You mentioned also just licensing the technology to an existing company. So what does that look like? I mean, does the researcher kind of help with that process too? Do they take a little bit more hands off? I mean, what does those scenarios look like?
So I'd say the difference would primarily focus on the fact that a license agreement to an existing company may rely more heavily on the company taking it in-house, so they may have more expertise internally and resources to develop it. There's still going to be the need for the faculty member to be involved, but you might have a quicker uptake if there's an existing company where it meets an existing need of that corporation, where they can apply investment and they have the expertise to move the technology forward. The agreement itself may be more of a front-loaded. What I mean by that is you would expect compensation earlier in that process if it's an existing company versus a more back-loaded arrangement if we're to start a company. Startup companies are pieces of paper with people named on the registrations. They need to raise everything, their team and the funding. So our terms allow for that. And so the university would take equity, for example, in lieu of cash in certain situations, or to offset the cash burden for the startup early on, whereas that might not be true for an existing company that can has the resources to pay forward, but we would take equity in a large company. So the terms do adjust based on the commercialization plan. The commercialization plan adjusts based on whether it's an existing company or a startup company. But the tech transfer offices are flexible, I know, in that regard, and really do want to build the terms of the agreement based on the company and the strategy.
Thank you. So, throughout this whole conversation, we've talked about money here and there, but we've never talked right at it and got a hold of that. So I think just to put everything in perspective, I'm going to talk a couple different things. One, what is the cost, to actually patent an innovation? And then once you get to the point of being able to license that technology to a startup or a license investment, there's obviously then money flowing back in. I mean, initially there's a lot of money flowing out, now there's money flowing back in. So where does all that money come from? We can talk to that. So I think it's always great for the researcher to understand exactly how much does it take to patent an idea. We're just looking at just the US alone. Like, what are some of the costs to take an idea?
Just in terms of patent application drafting and prosecution cost for that period, I would put it at, I don't know, roughly $20,000-$25,000, maybe something like that.
Okay. And if I wanted to take that same idea and protect my intellectual property in Europe?
Substantially.
So I think that is one thing that we do come against too, is with researchers, is they want, you know, they want to protect their idea across the entire world, you know, not maybe always knowing, you know, that, yeah, thousands and thousands, almost hundreds of thousands of dollars if you are looking at one.
Well, and just to qualify Jeff's numbers, the numbers a little bit. Typically, the costs come in stages.
Yeah.
You know, you file the application, okay, and then there are those costs, and then it just sits there for a couple of years, and then when prosecution starts up, every time you have a response to an office action, those are costs. So it's not like you have to come up with a $25K check all at once to pay for it. But people need to know that it isn't one of those things that, you know, you can do for $500 and be done and expect to get anything that is going to be useful. But really, the kicker is when you do try to file in foreign countries. The U.S. tends to be rather friendly to inventors. Our official fee costs are low. Okay, you get to Europe, you're responsible for paying what's called maintenance fees every year, and for other countries like China and Japan, there are translation costs. So, you know, it can be $10,000 to $12,000 to file an application in Europe. But by then, okay, anyone involved in this process should have spent quite a bit of time thinking about what their invention is and what its commercial value is. Just saying, oh, I want to file in Europe without any kind of a business plan that identifies what you're going to get out of this business in Europe is just throwing money away. You need to really tie the two together. It may be for some companies, filing in Europe is important, certainly for the pharmaceutical industry, it's global. Most people like to think that way, but for other kinds of inventions, you may not need it, or you may need to focus on other countries. It's not a given that you want to file everywhere in the world. Startup companies have plenty of other things to spend their money on as well, including clinical trials.
When you find a partner, I don't know if Temple and Penn State do this, but it's in a lot of universities. If you find a partner, a lot of those patent expenses then are paid by the partner once they get in. So if you're in a good situation where you spend maybe a reasonable amount, you file in the US or you just file PCT, that's an amount most partners can swallow. The tougher, and then if the partner, a lot of times will have strong emphasis on where they want to file. If they're covering costs, universities probably don't care about that. But where you sort of get in a bind is where you have this, you don't quite have the partner lined up, and then you say, okay, what do I do now? Do I file in Europe and Japan and China, or do I have more limited? Because you don't want to hamstring a future partner by not filing in a key country. On the other hand, you don't necessarily want to spend funds if I'm not sure you're getting them back.
And that's picking up on the timeline you raised earlier, because timelines are kind of cruel to startup companies, because if you have a deadline to file an application in Europe, that's a deadline. You can't say, oh, we'll do it later, because you'll lose your rights, you'll never be able to do it. So it's kind of an unfortunate circumstance in which companies find themselves, but I guess the most important thing you can do is be proactive early on to be aware of what's coming.
We do need to, strike that balance, because I'm at Temple, Jeff, to your point, generally the approach is we'll support the full-on filings, yes, if it's partnered out to a company, because it's the company that's going to have the financial ability to do that. For Temple, for example, to take on a foreign filing case for just one patent, say over just a year, it would probably consume 10% of our budget, right? So that's now taking a significant amount of resources into that one invention, and possibly taking it away from new ideas that are coming in that we do want to protect, that may have as much potential. So we need to be able to scale that investment in the intellectual property protection appropriately. And so typically we need that company partner to help us support that cost, but also identify the key markets that will be important for that corporate partner. what's happening is Gretchen, what you mentioned is you also have a primary mover of technology at startup companies. And startup companies also don't have the resources. So we end up taking a very limited but more strategic approach where if the US and Europe happen to be 70% of the market for a particular project, you might take that approach as a university, but not then try to capture the remaining 30% by filing around the country and increasing your cost significantly without that potential for return. So it is tricky. It does require as much planning as possible up front as to not to drag this down to the last minute, but honestly, it almost always comes down to the last minute.
It always does. But I think it's really good to understand, for researchers to understand the cost involved in the strategy that goes in and how you can quickly, tens of thousands, if not $100,000 wrap up in fees when you're trying to protect your, invention, beyond the US. And because I think that it comes back to looking at those startups and, looking at the licensees of why then, that Temple and Penn State and other academic institutions are looking to take an equity stake and why they're looking to take the positions they are and not just hand it out. Because there has been considerable cost involved to get that innovation to that point.
Absolutely, and we want to enable the startup to raise money. Investors are going to care about a marketplace, as big of a marketplace as possible. But the other consideration there is inventors also have a share of any income that comes into the institution. So at Temple, that's 40% after we recover our patent expenses. So if you build up an unnecessary hole in terms of sub costs as an institution, we also have to fill that back in before we distribute any revenue as well. So there's a lot to consider in terms of the filing strategy. It's a planning process that typically involves the university, the company, the researcher, and so on.
Go ahead.
I'll just make a quick point. It's even outside of the university level. I mean, you're talking even Fortune 500. They'll run into. I mean, this is such a significant expense that we routinely look at this when we're taking a foreign filing strategy. You'll have these conversations of, okay, this is something we're going to implement. Now, how many countries do we have? And if we pick off these 5 countries, are we going to have 70, 75% of the market? Is that enough?
Yeah.
And because the question is barrier to entry. If you can have enough of that world covered where you don't think a third party is going to come in there in the countries that you're not covered, a lot of times that's a more recent strategy and it saves those funds.
And the other thing that we factor into for large companies, but sometimes can come up with universities, is the relative respect for intellectual property rights in that particular country. Because, you have a patent to keep others out. Do you really want to be in a position of having to litigate that patent in some country where your rights are not going to be particularly respected? Is it worth it? Sometimes companies decide yes for commercial reasons, but other times they take a hard look at it and think we'd be better off elsewhere.
And that's maybe an entire panel in itself.
Yes.
Yeah.
Because we're seeing some of those countries represent significant marketplaces.
Sure.
And I think what we're seeing more and more of is an investor expectation that those are covered. So what is, but it needs to come down to what does that mean?
I think too, when talking to researchers, a lot of times, these initial innovations are so early, it might not actually be the innovation that actually becomes the commercial product, that you really are building a portfolio, of patents. So therefore, you might not want to necessarily need global protection for that very first stage, because you're going to be having other patent applications, forthcoming, as you continue the research. Do you see that as well?
Absolutely, and that's typically so if we had to make a decision where we retained U.S. rights or pursued U.S. rights but didn't pursue foreign territories or foreign filings, there is always that opportunity for that researcher to continue to advance the technology, develop additional IP. That additional IP has that same opportunity to then apply for foreign filings. The counter to that would be, what is it that you're actually claiming in filings, and whether you capture the key element of the invention in that US only filing or potentially a future filing. So for pharmaceutical, is it that chemical composition of matter versus, say, a method of use that is that later increment to the innovation. That's really hard to be able to sit there with the crystal ball and figure out whether or not you're going to have all the elements line up for you to pursue a foreign filing on a particular invention. Sometimes you have to make the hard choice. Universities typically retain, at least Temple does, US only, unless we have that commercial uptake, the potential, preferably a partner in the signed agreement. But yes, there's always that opportunity to add to your portfolio. We prefer that portfolio approach, and that additional portfolio has foreign rights still available.
I think that's a beautiful thing to segue back to the beginning of our conversation where communication is so critical. The fact that the researcher, I mean, they know the potential a lot of times of what they're working on, and to be able to have those open conversations with them saying, okay, this is what I know now, this is what I've invented now, but this is what I think where this is going to go, because then that could, help draft those initial plans and to be able to have that patent strategy moving forward.
Yeah, and that's a good point to come back, because what we haven't, I mean, maybe the audience knows this, but what we haven't said here is that a patent term is 20 years, okay? You don't have a monopoly forever. It's a limited monopoly, and the system was set up by Thomas Jefferson, the first inventor, to reward inventors, okay? But it's 20 years. It's limited. But for biotech, pharma, often these things are most valuable toward the end of their lives because it takes so long to run the clinical trials and get approval and everything. So none of us sitting here can predict the future. We have no idea what things are going to look like in 20 years. But what we can do is draft a flexible document. We can draft a document that we think can be bent and twisted and moved and fit things. And the most flexible documents, I think, are drafted with input from the inventors.
And you really, if I could build upon Gretchen's point, you want to look at everything else, but then you also have to be reasonable in terms of the scope.
Yes.
Sometimes you're shooting yourself in the foot if you try to claim everything, because you don't have enough to support that. And then later on, when you have these later filings, it's your own priority that gets used against you. So you do need to strike a balance in terms of how you're drafting the patent and building that portfolio, the Erika that you talked about earlier. Can often, you have that Venn diagram sort of thing to protect the invention. It can really be very nice.
That's why having the portfolio actually is to an inventor or a company's advantage, because, okay, you have an initial patent that's a platform technology for stuff, and then you go on and you have theme and variations and modifications. Well, you can license different ones to different companies. There are, and things can sometimes not go well. If for some reason one of them is challenged, you'll still have the other two. So it's better to have more ideas, not worse.
Well, this actually brings us to the end because we've been able to go full circle from everything from what is intellectual property to, intellectual property beyond the academic institution. Is there any final thoughts that any of you would like to share to the researcher at any stage? Nuggets of wisdom. I'm putting you all on the spot.
Yes.
I apologize for that.
I'll say this, just, and this is a topic that we talked a little bit about, so I'm not sure we touched upon here. And I'll steal your thunder a little bit, Gretchen, because I think you're the one that mentioned it on the phone, which I thought was a really great idea, was that when the inventors have this, it's not by getting involved with the tech transfer office, by filing these patent applications, by getting these partners out there to the point of commercializing it. That's when they can take this technology, all the work in the lab, everything they've done, and actually take that to the next platform. And you actually see some of those ideas really get developed. And even to the point, if you look at this, when you have a patent, when you see third parties and competitors like this, and they start coming in this area too, that's what really lifts the technology up. So I think by getting involved in the patent process and trying to take these ideas to the market, to commercialization, can really do a lot for the technology that's being developed.
And I'm just following on Jeff's point.
Because I stole yours.
No, I'm fine. I'm fine with it. One thing that I know many universities do quite well, but anyone of an entrepreneurial bent, there are plenty of programs and lectures and other things. You know, most people who are PIs or students or stuff, they're used to dealing with and mastering all kinds of complex subjects. This is just another subject they need to think about. So there's a lot of resources out there about what having a company is like, what you have to do, writing a business plan. You know, if anyone who's written a grant application certainly can think about what it's like to write a business plan. And it's very informative to sit and try and do that. You're staring at a blank piece of paper and suddenly you realize you have to explain to someone, not the NIH, why they should give you a little bit of money, but some investor why they should give you $20 million. So you have to be able to explain it. So any kinds of educational programs or anything that people can take advantage of, even if it's long before they think they're ready, is a good thing to do.
Yeah, and I think that's, I think that's a great point, and I'm sure at Temple as well as Penn State, I mean, trying to get those researchers involved into those educational programs early is so critical for them to be able to, explain their science in a way that an investor, can really resonate. So because $20 million is a lot more than your average grant.
That's what I was, and I'll turn this over to Steve, but we were talking about before this, the additional grant money that comes from this, the ability to have some of the grad students involved in some of these spin-outs and see them achieve this success. It can bring, I think, professors a tremendous amount of value if you're going down this path.
Perfect. That's great. Triggered right into my line of thinking for my final comments, which are, I said disclose early, disclose often, but also don't get discouraged in the process. So, because we can't pursue something doesn't mean there's not an opportunity. Oftentimes it puts it on our radar. We can identify grant opportunities or tech development funds that are out there to help get your idea to a stage that makes it palatable. It makes it investable from maybe a startup perspective. So you should never hesitate to get the idea into the tech transfer offices. We can help set that bar in terms of what would make something patentable if it's not something we can pursue today. And really enables us to understand the line of thinking, intellectual property from a particular researcher or lab and help them get to a point of success. So it should never be a negative process. It should be a positive effort to help get your ideas to a state where you can advance them.
Thank you so much. I really appreciate Gretchen, John, and Steve. I really appreciate your time. I do want to do another thank you to MBM Associates and also to our host University Place Associates. If you would like to learn more about BioStrategy Partners, please feel free to go to our website at biostrategypartners.org or even connect with us on LinkedIn at BioStrategy Partners. Thank you.
Thank you.